Welcome to Off the Clock. Last time, we talked about different strategies to reduce labor overhead and costs, short of involuntary reductions or restructurings. This time, we're going to focus on reductions in force and a step-by-step process that avoids or minimizes legal risk. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
So now we're talking about involuntary decrease of headcount, downsizing,
whatever you want to call it. Yes, there's organizational restructuring seems to be the just so our listeners know, that seems to be the term of the moment, rather than RIF or reductions in force.
It doesn't inherently mean a reduction.
Yeah,
but I've never seen one.
But it really
doesn't.
That's exactly right.
Somehow people are fooled,
right.
though.
That's exactly right.
Don't say it in the title. But yeah, a lot of HR folks commonly refer to them as RIFs, right? And so we'll probably use that.
Yes, we'll use
today.
either term. Yeah, interchangeably. I've had a lot of recent conversations, and I'm finding many HR folks, and this is a wonderful thing, have not lived through or led a reduction in force from an organizational standpoint. The last time we saw a lot of RIFs was really back in 2009. And I'm not counting COVID because I view that as very different. That was very sudden.
Correct.
Right? And everybody understood what was happening and the why, et cetera. Right? So I'm talking about an organizational decision to reduce headcount due to economic challenges of the moment. And so what we've done is we've put together a 10-step process for our listeners. Not a program.
It's not a 10-step program. You can go elsewhere for that.
This is a program.
A 10-step process for reductions in force. And I think having structure around it is so important because it's an area fraught with anxiety.
That's exactly right. Where do I start and where do I go next?
Not just because we want to do it right. Yeah. But we already know the end point is going to be bad news. Right. For a lot of people. Yeah. And so we're already starting to absorb, that anxiety. We're thinking 10 steps ahead to the conversations with the impacted employees. Emotions are high. And let's not forget, the business leaders and HR folks on the planning end may also be impacted, and they know that. Right. And so lots of anxiety. So whenever that's the situation, we strongly believe having a process or a tool to fall back on, can help you take that first step.
We're going to be high level with every step. Good news for our listeners, right? Because some may be hearing, oh my God, I have to hear them talk about 10 steps. Good news. We're going to stay high level with each one of them. So this is going to provide more of a roadmap. So let's jump in. I'll start with step 1. This is critically important, and it is likely to involve an HR professional and almost certainly their upline, whether it be the COO, the CEO, et cetera. And that is identify the reasons for the reduction and the goal, the why and where do we need to get. And get alignment. Make sure we're all on the same page with what those things are. This seems really basic. But if we don't have those firmly established, we can get unmoored very quickly as we move on to the next steps in the RIF. Yes. So coming back to, as you refer to it as the North Star, right? What is our why? Why do we need to do this? And what is our goal at the end?
My only yes and there is sometimes I see those decisions being made without HR involvement. That's up to the organization at what point to involve HR. But if HR was not involved, they need to ask the whys then, right? Because it's going to be HR, probably not anyone in that closed executive suite, but HR who's going to be on the front lines making decisions with supervisors. And we need to know what the reasons are for it to make good decisions. What's next? Step 2. Once we know what the goal, the reasons are, then we need to determine in broad strokes what organizational changes are necessary. Yeah. We're not talking about individual employees yet. That's important to say because when clients are involved in these discussions, someone in the room is going to want to get straight to names.
Yes,
It
that's right.
happens every time. We really need to resist the urge to do that.
Yep.
Right? Because that is not going to serve the ultimate goal. So we need to talk about what are the organizational changes without personalities involved. We're going to look at whether it's certain shifts, whether it's certain business lines, whether it's back office versus production or vice versa, where we can make reductions to meet the goal.
To meet the goal,
North Star
exactly, which is
goal.
the why. That's exactly right. Two things I would add to this step for folks that are important. The first one is this is probably where we're going to begin to sketch out a timeline, right? Once we understand what organizational changes are necessary, we can start to better understand the timeline of when final decisions are going to get made and when employees are going to be notified.
Right.
The second one is very important, and it comes with two parts. Maybe it's a second and third one. The first one, the WARN Act is next.
The WARN
right?
Act, one of the best named statutes there is.
So at this point, we should have our arms around the scope of these changes of a reduction. And that should allow us to begin to understand the likelihood that WARN Act notices are going to be required. Now, we're not going to talk about specifically about what those events are and when the WARN Act is triggered.
Too much for today, but you
Too
should be
much for
asking
today.
questions.
And the reason is important because those notices are 60-day notices. So you don't want to wait to start thinking about that until the week before you think you're going to be notifying employees of decisions. This is the point in the process to think about that. And then the last consideration at this step 2 is determine whether the organization received economic incentives.
So important. Yeah.
That for which obligations may be triggered.
Yes.
By reductions. Okay?
A lot of incentives are there to have. They're based on headcount or things like that.
And by that, we're talking about like tax incentives with state and local governments.
Yes.
Right? The organization might have gotten a tax incentive to open a facility or build a facility, and tied to that is some sort of guarantee that a certain headcount is going to be maintained for a certain period of time. And if not, money might have to be paid back. You're going to want to know at the front end whether any of those obligations exist and exactly what they are to hopefully avoid repayment obligations.
One add onto the WARN Act, in addition to notifying employees, it usually always requires notifications to state and local governments as well. So if you are going to be covered by the WARN Act, this would be a good time to get your communications team involved, right? Because there'll be reputational issues to manage there.
All right. Should we move to step 3? We're already on to step 3.
We're not used to moving this fast.
Okay,
I'm getting a little breathless, but this is like doing speed work. But I love it. It's challenging.
Step 3 is begin to define your selection process for identifying the who. Now, you mentioned step 2, we're talking in larger terms or organizational terms, not individual names.
This is where it gets hard.
This is where it gets hard.
We need to be
We're still not selecting the people yet, but we're identifying what criteria we're going to rely on when we have positions that are impacted and there's more than one person in that role. Okay, so to be clear, we may have positions that we've decided can be eliminated and there's only one person in that job, and that's fine. Obviously, that person can be selected. But almost always, there's other roles that are impacted, and there's a number of individuals in that role, or a few, whatever it is, and we have to pick who is going to be impacted, okay? So our advice, and I know you're on board with this too, is it's really important that we decide at the outset what those objective criteria are going to be, and decision makers across the organization are following the same playbook.
Yes, and I will also say, keep in mind that multiple criteria can be used in the same decision making, and you can weight them differently. You can award 5 points for perfect attendance and 1 point for seniority, or flip those around, or whatever you want to do. And again, weight them differently depending on the importance of the organization, and the people with the highest points or the first let go or the lowest points, depending on your scale and criteria that we have both seen over the years. Seniority, for sure, with the organization, but also sometimes experience with the job. For instance, a nurse, we may not care how long she's been a nurse or he has been a nurse here, but we want to keep the most experienced nurses
Correct.
on the floor, right? So you can consider really anything other than protected characteristics,
That's right.
or groups. But other types of valid criteria that we've seen clients use.
So the most common ones I see are length of service with the company,
Mhm.
job performance.
Yeah.
Usually that comes from job performance reviews, scores and
Mhm.
reviews, skills and or cross training depending on the organization and what you do, right?
Love the cross training one. Yeah.
In other words, is this person a utility player?
Mhm.
Meaning we could use them across a number of different roles, or are they really specific to only one job?
Mhm.
Attendance.
Mhm.
I think those are the most common selection factors. But of course, as you said, I mean, you can be creative. The only rule is it can't be a protected class, right? It can't be age, disability, etc. And then, of course, it also can't be use of FMLA leave or other protected time off.
Yeah, we're going to dig into that in a little bit because that is a significant risk factor in these processes, as we've both seen. Step 4 is deciding what the separation benefits will be, if any.
If any.
If any is
So
important.
question for you, do we, in the context of a RIF, are we required to pay separation benefits and give employees a separation package?
In a world where there's no collective bargaining agreement or other employment contracts, the answer is no. And that surprises a lot of clients because it's so commonplace. We've all grown accustomed, right, to layoffs, reductions in forces coming with some sort of separation benefits. But it is not legally required.
Okay.
And if your company is in serious financial straits, right, and that's the reason you're doing this, or let's just say an organization that's funded by grants, et cetera, and the grants are just gone, right? Separation
That may
benefits
not be an option.
might not be an option.
Yeah.
And that is demoralizing, but it's not unlawful.
Yeah.
Separation benefits, if any, you want to think about whether there's already a policy or plan in place. Sometimes I've seen handbooks that go into that level of detail.
Yeah.
So take a look at that. If not, and you've got a blank slate, think about obviously the pay. That's what most people think of. Make sure it's some sort of objective, consistent pay for every employee. A week per year of service, a week per 2 years of service.
I get that question all the time.
Is.
How much?
How much?
How much should I provide? And my answer is always there's really no legal answer.
Yeah.
Okay, but to inform your decision, if somebody were to go Google, right, how much severance do people get?
Yeah.
For reasons I don't know. Somewhere along the line, this kind of rule of thumb happened, which is a week per year of service, or maybe 2 weeks per year of service, depending on position. I don't know. I honestly have no idea where that originated, but it's just out there.
It's just easy. Let's just face it.
And that's where many employers, and some employers have a minimum threshold, right? At least 4 weeks, 1 week per. Yeah,
and a cap it too, up to a maximum of 26 weeks of pay or something. That doesn't have to be the maximum.
Exactly.
But yes.
Yeah. And then other types of benefits we often see, if health benefits for those enrolled in the health plan, you could support them with continued health benefits either through payment of their COBRA premium or giving them money to go buy their own benefits off the exchange.
Right.
I just a quick caveat, it will almost certainly not be allowed to just continue them on your benefit plan once their employment has ended. So I want to be really clear about that. That does not, and that can create a tremendous risk of liability to the company if we tell employees they're covered under our plan, when in reality the plan will not cover them.
Yes, and it's COBRA and we're paying their COBRA premium, which is really what the client
That's the right way to do it. The wrong way to do it would be just to tell them, don't worry, we'll just continue to cover you under our plan.
Good point. Okay, let's talk about some that sometimes people don't think about as much. One is providing outplacement services. You can cap that a certain amount of weeks, right? That they can, or a certain amount of visits. For instance, you can pay unused PTO. It's a nice opportunity for PSA there because they get this question year in, year out. Under Michigan law, you do not have to pay out unused PTO unless your policy requires you to do it, in which case then you are required to do it. You can pay bonuses that they might not otherwise have earned or be eligible for given their separation date, but you can opt to pay it in full or prorate it, right, as a nice measure on their way out. Letters of recommendations or references can be very, very beneficial.
Right.
To folks. That's something else we can
a simple statement, yeah, exactly. I mean, most employers give a neutral reference if they get called. I've seen in the context of a reduction or restructuring something saying if we get contacted, we actually will tell the prospective employer that your employment ended because of a restructuring.
Right, a reduction in force. It was not a reflection.
It was not a reflection.
Yep.
Okay?
Yep.
We'll talk more about putting together the actual agreements in a few steps, but those separation benefits should be provided via a separation and release agreement, and that release agreement can also contain terms that are helpful to the business, starting with a full release of claims.
Starting with the release.
Non-disparagement, a promise to return all property, confidentiality, and all of those good things.
Yep. So we can start coming up with the templates for those even before we get to the next step.
You got it. Okay, let's move on.
Step 5?
Let's move on to step 5. And this is an important one, right? So now we've sort of laid the groundwork, right? We know the why. We understand the impact on the business. We've identified our selection factors. We've decided whether or not severance is going to get paid. Now it is time to align with and educate our decision makers so that they then can begin to make selections of which employees are going to be impacted. Okay. I am a big fan of having a really, really good communication plan that has some written materials to provide to those decision makers so that we are as consistent as possible.
Yeah.
They understand the North Star. They understand what we're doing. They understand what the criteria are, and we're all working from the same playbook. And then under this step 5, of course, they will begin then they will be making those selections, right? So they will be told your job is X, and they will begin to decide how to achieve those reductions or savings within their area, applying the selection criteria we've given them. Now, this is a step along the way in which it probably makes sense for the organization to consider involving legal counsel,
right?
Because this is the place where there may be communications to which the client wants the privilege or work product to apply. So one of the benefits of calling a lawyer is it allows businesses to have certain communications and information protected under the attorney-client privilege.
Right. Kid, for people that aren't familiar with that phrase, it means it's confidential. It means no one, if an employee gets upset and sues you, none of those communications will be revealed. So everyone can speak freely and honestly and get the legal advice that they need.
Put otherwise, then, if there's emails going back and forth between HR and a leader about decisions and legal counsel is not involved, those communications will all be subject to discovery and discoverable in litigation. So if you're not involving legal counsel, also bear that in mind.
Right. Good. Very good PSA. All right. Step 6 is where the lawyers can really add a lot of value, not to toot our own horns, but this is where we often get involved if we weren't already. And this is analyzing the potential selections. This is a step that some clients miss. We usually find out in litigation. After there's a lawsuit is when we find out that the step was missed. And this is, again, the analysis, the risk analysis, we can say, right, of the potential selections. And there's 2 components to this. One is confirming the factual accuracy that formed the basis of the selection. And this is useful for some clients, less useful for others, but if people find this useful, we've developed a questionnaire. So for each selection, right, the leader is required to answer certain questions that point us in the right direction, right? So we understand what their thought process was, and then we can confirm accuracy. For instance, if one of your criteria is performance.
I was going to say, this is the number one example.
Reviews,
right.
And they're all 5 out of 5 stars. We're going to want to ask more questions. Doesn't mean it's a no, but that's a risk factor. So we're going to want to ask more questions. If attendance is one of your factors, we're probably a person scored poorly on attendance, we're going to want to look back to see if any of those attendance issues were in fact protected absences under FMLA.
By any of the acronyms,
Exactly.
right? ESTA, FMLA, PWFA, ADA, etc. Okay.
Correct. Yeah, we're gonna want to work with HR in doing that risk analysis. Again, the answers aren't necessarily no, but whenever there's risk, we want to make sure people are making informed decisions.
Yeah.
Right? So we want to be able to evaluate what is the level of risk. This is high risk because your supervisor's lying. Or some risk, everyone's being completely honest, it's a completely valid reason to select this person, but on paper, right, it could look like X, Y, Z, so you have to be willing to take that on. All right. The other aspect of this is looking at the impact more globally across a certain division or organization. And what a lot of people do in this area is focus on age, right? But there's also other protected characteristics to look at, like gender, et cetera. And we say, are these decisions impacting a certain group of people more than others? And then that's not a reason to necessarily say no, but we do have to dig in. Why is that? Right? Why is it impacting? And, and is there a legitimate business reason, right, that's creating the disparity between one group and
That's
another?
exactly right. In other words, if that's the case, it's possible we may down the road have to explain that. And we'd rather have the opportunity to make sure that we're right and we have a valid and legitimate explanation now.
Yes.
Right? And even documented.
Yep.
Right? This is how we landed with each of these decisions. And nothing may change, but it's so much better to be aware of it. I can't emphasize enough, again, the importance in these conversations for those to be potentially privileged.
Yes.
And involving legal counsel.
Couldn't agree more.
Because that really is our transparent and honest communications you want to be having and conversations you want to be having, not subject to legal discovery.
Correct. And speaking of where lawyers can add value, Sarah, step 7?
Step 7 are the agreements. Okay, so now we've identified, we've confirmed which employees are going to be impacted, and now we are finalizing and putting together the specific agreements for each one of them, assuming that they're going to be offered some sort of severance or separation benefit. Okay?
Yep.
And those agreements, we would also suggest involving legal counsel to make sure those are done correctly. For group decisions like this, not only do we have the usual components of a separation agreement, but for groups like this, there are very specific disclosures we have to provide in order to get a valid release of an age discrimination claim of anybody 40 years and older.
Correct.
And that is legally heavy analysis to make sure we're compliant with the OPWA regulations and that that's done correctly.
And something that comes up in this area is to remember that when it's more than one employee involved, people have a 45-day waiting period as opposed to the regular 21-day for
that's
employees.
Right. And that's very important.
It is very important, and clients can make the decision about whether they give only employees 40 and over the extra days, or whether they give everyone 45 days. Sometimes it's just easier administratively to give everyone the 45 days, but it's really only necessary for your employees who are 40 and over. So remember,
at least in Michigan.
In Michigan.
This is a caveat, I will say too. There's different state laws that require different consideration and revocation periods for these release agreement. So yes, that's exactly right. And then the federal law has not only the 45 days. Since you mentioned the 45 days, I'd be remiss by not saying you also have to provide a list, an explanation of the decisional unit. In other words, which employees were considered to be impacted for this group decision, and the job titles and ages of those who were selected and who were not selected.
That's a very specific part of these separation agreements that employers who have not been through a RIF might not be familiar with. That list is its own project, so you'll need legal assistance with that to make sure you're getting the group exactly right. Steps 8 and 9 might be 9 and 8. We're not really sure.
Depends on the organization.
Depends on the organization. There are two different steps, and we can talk about which should come first, the chicken or the egg. One step is the communication to all employees, and the other step is the communication to the individually impacted employees.
And both are important. So we're going to have a meeting with all employees. Usually, whether we mean every individual who's employed by the entire organization will depend on the size of the organization, right? If we've got a huge multinational company, it could be a division. But generally speaking, we're going to have a meeting with all employees who are touched by this in a meaningful way.
That's a good way to put it.
And we are going to explain to them, we're going to have to take 8 steps back with them, right? And explain to them the why for this. And we're going to have to tell them which, generally speaking, which parts of the business are impacted. And I usually like generally telling them, without a tremendous amount of specifics, but generally telling them what the criteria were to select who was impacted. And the reason we do that is because, number one, providing employees transparent information to employees is usually helpful in this way. And it makes clear to folks that we really did have, although this is hard, we really worked hard to apply consistent, objective, transparent criteria so that we're making decisions as fairly as we can.
I completely agree with that. And I think a lot of clients skip over, not our clients, but a lot of employers who are not our clients skip over that step, or at least make that meeting as short as possible because they think it's uncomfortable, which it is, right? But by skipping over the specifics, you're actually making people more uncomfortable and fearful than you would otherwise. All right, so either the next step or the prior step are the meetings with the individually impacted employees. In those meetings, I think most HR professionals have their heads around. You're going to provide the reason, the business reason, the individual selection criteria, how they fit in with those criteria, the impact on that individual, how long are they going to continue working, for instance, and then the offer, the severance offer, if you're making one, the severance pay, the benefits, et cetera. So let's just talk quickly about the pros and cons, right? Which should come first, the group meeting or the individual meeting?
Yeah, I mean, I think it really depends on the organization, quite frankly. High level, I think there's pros and cons on both sides. It's going to depend on the size of the organization, whether everybody's in the same location, whether we have a lot of folks who are working remotely and in different states all over the country. Employers should assume that after they've met with the very first person and used words like restructuring and reduction in force and separation package, word will get out quickly to everyone else. And so that can send panic if we haven't first had the meeting with all employees to explain to them what's going on. So one of the pros of doing the all-employee meeting first is that it cuts that off, right? Everybody, we level set and everybody's on the same page, and there's not rumors and speculation after we've had that first meeting. I see that probably as the more common order. The downside, of course, is once you have the first meeting, then everybody's talking, freaking out, looking around.
They're scared to death.
Every time their phone rings, They're looking to see whether it's HR calling them, et cetera. So it can be a very disruptive time in which very little work is probably getting done until we can get through the follow-up meetings.
So one of the decision points might be how many people are individually impacted by the decision.
Absolutely.
If it's 2 people, maybe you just inform those 2 rather than, and then inform everyone else. And if you were impacted, you've already been notified. Right? That way.
Yes. Depending on the order. And if you do the all-employee meeting first, I generally like to be able to say, we will be providing individual notices, et cetera. Those will be completed by X date.
Right.
So that people know they've got an end date in their mind. We're done. And they're not continuing to wonder.
And then, of course, it goes without saying, but then I'm going to say it. If you do the group meeting first, get those individual meetings done quick.
Yeah.
Back to back. Do not drag that out.
Yes, exactly. Okay. So finally, step 10, it's a quick and easy one. And that is just track for if we've given folks agreements to consider, right? Continue to follow up and keep track of who's signed and returned it to us, who hasn't, and for those who have, make sure we're complying with the terms of the agreement in terms of separation pay and benefits.
Quick follow-up on that. I've gotten this question. The 45-day period to consider the agreement, some employers asked, does that mean they have to stay employed for 45 days? And the answer is no. There's no, subject to the WARN Act, there's no minimum notice requirement. The 45 days is the opportunity they have to consider the agreement.
Right.
Not a time period with which they have to be employed. Okay, well, this is not a fun topic, Sarah, but I think super helpful to a lot of people.
Awesome. Thanks, Rebecca.